This Guy's Garage. Like and subscribe.
I have so much to go through here. I'm going to start with Professor Benedette here, and talking about low risk versus no risk. As my colleague Mr. Brock points out, the best predictor of future behavior is past behavior. So given that issue, does it not follow that we should be considering mandatory a mandatory triggering, especially for a sex offense against a child?
Well, I would say yes. Certainly a sexual offense against a child that attracts a sentence of imprisonment, whether custodial or conditional, is a serious offense. And the route at which that is prosecuted, summary conviction or indictment, is really irrelevant. It's the facts of the offense and the penalty it attracts that speak for themselves. So, yes, it seems to me that is a circumstance in which mandatory registration is justified and could be supported as constitutional if that were to be challenged.
Now, one thing that I was reflecting on, and anybody can chime in on this, but let's say if we had a joint submission, which essentially ties the judge's hands, except in very rare circumstances, where discretion isn't where registration isn't mandatory. Theoretically, you could actually have a plea bargain that would say this joint submission is such that we're not asking the judge to impose registration under SOIRA. Would you agree with that? Any of the witnesses? How about Ms. Parker? Perhaps you have a fair amount of knowledge in this area. Feel free.
I'm actually going to defer to, I don't feel I should speak on SORA here today.
Yeah,
I'm actually going to defer to my friends who've studied this much more than I.
Okay.
And I'll defer to
Professor
Benedette first, of course.
If this isn't within anybody's realm of knowledge, I'll just ask another question.
Well, I'll just say that as I read the legislation, the way that you have structured it, I'm not sure that could be plea bargained away, because even where it's not mandatory, it's presumptive. It's only the secondary offenses where the application has to be made, and that could be the subject of plea bargaining. It's a complex piece of legislation, but that's how I read it. That was certainly a problem in the past where the prosecution had to request the order, but I don't read this legislation as going back to that model.
Just going to ask one more question, and then I'll give the floor to my colleague, Mr. Van Popta. When we talk about child sexual abuse material or child sexual abuse and exploitation material, referred to in the code as child pornography, but I don't want to use that term here. My understanding is that the research says that a number of people who consume this type of media, if memory serves, upwards of 80%, will eventually offend against a child. Not only over the internet, but in person. Now, would that not itself be justification for mandatory registration for these types of offenses? Professor Fair, go ahead.
Sure. So the constitutional question turns on this very narrow principle of justice called overbreadth. So if you can find one case where this would apply in a way where that person predictably would not be able to offend or would not likely offend, then the Supreme Court says that this is a violation of Section 7 of the Charter. I've written as to why I think, in fact, that principle of fundamental justice is not fundamental to justice at all. But then it goes to Section 1 justification. And the question we would have to consider is whether the discretion that's been so problematic, whether that getting rid of that and the offenders that will fall through the cracks is worth catching those one oddball cases where we might be able to find someone who is not unlikely to reoffend.
Mr. Van Popta here.
Okay, Professor Benedette, thank you for being here. Thank you to all of you. Now, Professor Benedette, you said that you affirm or you agree with what Professor Fair had said about listing the reasons that a judge cannot consider in determining whether or not somebody's name should be added to the sex offender registry. Could you expand on that? I think that's going to be important for us when we do our clause by clause.
Sure. So I'll just give you an example. So right now in the criminal code, when we talk about an application to access counseling records, third-party records, private records of the complainant, there's a list of factors that the judge is not supposed to consider, or at least are not sufficient justification for ordering production. And that was done specifically to try to counter some of the problematic and myth-based reasoning that we had seen in the past.
So, Ms. Benedette, I'm going to interrupt you now, and we'll go to our next questioner, and perhaps you'll have an opportunity to pick that up. If I don't...
You've given very important evidence about one aspect of Bill S-12. Your focus has been on publication bans, which is very important legislation, and we are generally supportive of it. But I just want to get on the record how profoundly disappointed I am that the government, that the government side of the House has delayed this legislation and is now rushing it through. We have a deadline of October 28th in response to a Supreme Court of Canada decision that said that the sex offender registry was unconstitutional. So Bill S-12 intends to fix that. But now, on top of that, we also have this second add-on of a publication ban. And, listening to your evidence today, Ms. Rick particularly, you say, there's a lot of voices that haven't been heard. And here we are in a big rush. We have October 28th to get this whole bill passed. And I just don't feel that we're giving just time to this very important piece of legislation. Now, that said, that off my chest now, I do want to thank you for your testimony. But perhaps you could, we've heard from other witnesses that have said there should be a simplified process for eliminating, revoking the publication ban in simple cases. But perhaps you could tell us what, in your mind, constitutes a simple case.
I'd say perhaps a case where there is a very narrow scope of individuals who are covered by the publication ban, so a single individual, a single victim or complainant, where nobody else's interests are impacted. So that is juxtaposed, of course, with cases where there are multiple complainants, where there are different privacy interests that may be competing, where you have different desires among those individuals to have the privacy protections of a publication ban and those who do not want those privacy protections. So I think that's the kind of case that might be a little bit simpler. And I do think that the amendments that have been proposed and adopted by the Senate to simplify the process are a great improvement over what we have now and a great improvement over what Bill S-12 initially proposed.
Thank you. Now, there's often cases where there's more than one victim. And of course, there might be a disagreement amongst the victims as to whether the publication ban is important or harmful. So a case like that would be more complex. What would be the process then for revoking the publication ban for one victim but not the others?
So I'd hesitate to give a blanket answer, and I think the legislation provides for a process that allows those voices to be heard and for courts to consider whether a tailoring of a publication ban could address those various privacy interests. So I think it would be a case-by-case determination, and that S-12 does give the tools to the court to be able to make that kind of decision, one that hopefully, to the greatest extent possible, allows for every victim or complainant's wishes to be taken into consideration and to ultimately be respected.
Okay, thank you. Does the court have the resources to be able to do this in an effective manner?
I think the courts are under-resourced as a blanket statement.
Fair enough. I would agree with you, certainly from evidence that we've received in this study and others. I have a question about Crown prosecutors being given this additional task of having to deal with victims and publication bans. And I don't know which one of you said about that. I think you were indicating that there might be a conflict of interest between, for the Crown prosecutor to have to give what effectively becomes legal advice. So perhaps you could expand on that. Maybe you, Mr. Robeck, could talk about that. and tell us what needs to be amended in the draft legislation.
Thank you. Yeah, I have a sympathy for that conflict of interest that I've been hearing about. I think independent legal advice is one of the most important components for survivors. It's a complaint that we have, that even though programs to provide independent legal advice exist, nobody has a responsibility to inform victims when they report a sexual assault that they can access those programs. And so it's a gap. We don't tell victims about their rights up front, and so they miss out on exercising them. For multiple survivors, I don't understand why somebody in cases with multiple publication bans, where somebody would need to retain theirs to respect someone else's. I think in cases with multiple bans, that somebody should be able to have their own removed and still respect any bans that remain in effect. And I think that that's a clear distinction. Otherwise, we have a system where people are still trapped with these silencing measures, and I think that needs to change.